And Kelly Piddle, do you have your documents? They've already been signed?
Judge, I haven't received any for any documents. I'm just waiting to sign them, and then I'll go over them with my client. They'll be sent to him.
Okay. Norma?
Yes, ma'am.
On Kelly Piddle's client, Mr. Francis, for the motion to revoke this afternoon, can you forward him a consent to plea and a trial court certification, please? How many cases does your client have?
2, Judge, the MTR and then the new case. I can email her or chat her the cause numbers if she needs them.
All right, the new case, nothing's happening with that. Is that correct?
No, they're both being resolved today, Your Honor.
All right, but the new case, there's not going to be a plea on that?
No, there is. It's
Okay.
It's to run concurrent.
All right, so if you will put in the chat box to Ms. Ferguson what the agreement is on each case, then she'll get the documentation to you.
Okay, I did that. I think she should have it if she.
Yes, I do have it, Kelly. I just saw it.
Yeah,
Yes,
cool.
thank you.
Of course.
I'll get started on it right now.
Great, thank you.
Tom, I'm sending you a chat. And Joe Ray, I'm also sending you a chat. Which case are you looking for?
Alice Francis, but he has another case.
Yes.
It's not there.
No.
I have to get it.
Thank you. Does anyone know who Tiffany Dean is? Who is she with?
She's the complainant on the contested MTR today, Judge.
All right, thank you.
You're welcome.
Judge, my client just texted me with a question and I don't quite understand it. Can I ask him to leave the courtroom and I'll call him real fast and make sure I give him a proper answer?
Sure. Yes. Mr. Emeterio Hernandez, your attorney is going to call you on the phone.
Yeah.
All right, if you can let him know, Deputy Laura, that his attorney is going to call him on the telephone.
Yes, Judge, he stepped out already.
All right, thank you. And Joe Ray, have the motions to dismiss been taken care of on the case we did this morning?
Judge, I just sent you one. The other one is a misdemeanor.
Okay, thank you.
Oh, I know what you're talking about on the sentencing hearing. Let me check.
Yes. All right, thank you. Did you need something?
Yeah, Judge Ferguson.
Mr. Piddle, how did I do?
All right, James Toshi, you're back.
Yes, Judge. May I visit with Ms. O'Brien? We've yet to chat. Hunter and I did have a decent discussion.
All right, Ms. O'Brien, I'm sending you to breakout room number 1. And Mr. Toshi, if you'll go back to 1.
Yes, ma'am.
And Kelly, paperwork should be coming to you shortly.
And there you go. You're on. Thank you, thank you, thank you. We've been lost.
Can you see me? I can see you.
Yes, we can. Just give us a moment, Mr. Ruiz.
No problem. I mean, I'm not too familiar with the thing, so I was just starting early, so I won't be too late, for the meeting.
Oh, no problem. I appreciate it.
Judge, on the dismissals from the one this morning, most
Yes.
of them, almost all of them were at large waiting indictment, but there is one night mag one I'll send you.
All right, thank you.
This is from Anthony Moray.
Okay, thank you. All right, James Toshi on Miss O'Brien.
Yes, Judge, we were able to chat for a little bit. We exchanged information in terms of contact. We're definitely not going to get resolution today. I'd like to get some discovery and get to know Miss O'Brien and the case better. So if you could kindly just give us a whatever reset you can, at least 30 to 45 days, I would appreciate that.
Norma.
Yes, ma'am.
On Rebecca O'Brien, can you recall this for 30 days, please?
May 19th. I'm sorry, I thought it was a meeting.
May 19th.
Yes, ma'am.
All right, it'll be May 19th, Mr. Toshi, and the previous attorney on this was, I believe, Oscar Hernandez. So if you would like to talk to him to see whatever information he has.
I can definitely.
Thank you.
do that. Judge Boyd, I do have another matter, but I see that you have other clients and lawyers waiting. What would you like me to do?
If you want to, we have a contested, well, not a contested hearing, a bond hearing at 2. If you could probably Zoom back in at 3 o'clock, we should be done.
I definitely can do that, and I will. I'll come back at 3, Judge. I appreciate your time.
Hey, Jim
All right,
and Judge,
yes,
can I go back into a breakout room with Mr. Tochi, please, ma'am?
sure. If you all will go back to breakout room number 1, please.
Okay.
Thank you, Judge.
You're welcome. And are we ready on Colin Hobbs on your Immaterio Hernandez?
I believe so, Your Honor. I see Joe Ray's here, and then I see John Herman just logged in. My client and my witnesses are in the courtroom already.
Okay, we'll take this up. Brent, are you ready?
Yes, ma'am.
Into the courtroom. I see you already have him there. Thank you, Deputy Laura. All right, the court is going to call 2019 CR 8395, State of Texas versus Immaterio Hernandez. Can I have parties announced for the record, please, for the state,
Joey Garcia for the state.
for the defense?
Colin Hobbs for Mr. Hernandez, Your Honor.
And are you Mr. Immaterio Hernandez?
Yes, Your Honor.
All right, we're here for sentencing. Just one moment, everyone. Off the record for a moment. Mr. Toshi, I'm sending you to breakout room number 1. And Mr. Morris, if you could go to breakout room number 1, please. All right, we're back on the record. We're proceeding by video because of the pandemic. Any objections from the state?
No, Your Honor.
Any objections from the defense?
Oh, Your Honor.
For the record, Mr. Immaterio Hernandez is in the courtroom. This is not one of the in-person days that the court has. However, the court has received permission from an administrative judge to conduct this hearing in person. And I will note for the record that the previous plea was entered by video. And have each party had a chance to review the PSI report, and have you received the report?
Yes, Your Honor, we have.
Yes, Judge.
All right, any objections
None
to
from
the
state.
report?
Judge, no, we don't have an objection, but we do have some clarifications that I think some of the testimony will bring forth. In particular regarding, there was some mention of bruising on the complainant that night, that I believe that when she talks to you, she'll tell you there was no bruising amongst
All right,
others.
so let me, according to the plea bargain agreement, the state is proceeding on the Class A misdemeanor. The state is recommending deferred adjudication. So the reason why we're here today is because the court wanted information from Veterans Treatment Court or either from a MIC-MIOF evaluation. So my understanding, there are personnel here from Veterans Treatment Court. Is that correct?
Yes, ma'am.
All right, so let's narrow it down to where we are. And where we are is the court trying to figure out what conditions to place on Mr. Hernandez if I follow the agreement that you've been reached. So does anyone have any update on the Veterans Treatment Court for the court?
Judge Boyd, if I may, I could, we did assess Mr. Hernandez and
All
go
right,
through.
just 1 second. All right, does anyone have any objections to the court hearing from Veterans Treatment Court? Defense?
No objection, Your Honor.
State?
No, Your Honor.
And are you all okay with proceeding with this without question and answer?
Yes, Your Honor, that's fine.
Yes.
Is anyone requesting that Mr. Herman or Ms. Alvarado be sworn in?
No, Your Honor.
All right, so Mr. Herman, if you can give me an update on the Veterans Treatment Court, or Ms. Alvarado, if you could, please.
Yes, ma'am. So we went through and did our normal assessment with Mr. Hernandez once the referral came through. And we did submit, after the state assessed our findings, that a referral outcome that at that time he was not accepted into the Felony Veterans Treatment Court. I did have an opportunity with Ms. Alvarado to speak with Mr. Hernandez in between the court breaks today, Judge, after I gained your permission to do so late this morning. We had a wonderful conversation. It actually opened up a little bit more doors that were originally closed. And I can state that as of this time, Judge, I would love to have an opportunity to reassess Mr. Hernandez after Mr. Hernandez follows through with a few things that I laid out for him, whether he's in the program or not, as a veteran with his treatment and mental health. I do know that we're kind of late in the game in regards to his where we are in settings, Your Honor. So I can't guarantee you that we could get an answer as an acceptance today. However, after speaking with Ms. Stewart, our ADA representative, she is giving me the okay that if this veteran is granted probation, Judge, if you could put a condition for a reassessment, we will follow through and be able to do so after Mr. Hernandez comes back and works with me a little bit more.
All right, and what is the length of Veterans Treatment Program?
If accepted, Your Honor?
Yes.
The length of the Veterans Treatment Court program, it runs for 2 years. And additionally, upon graduation, you have a 6-month aftercare. So we request for 2 years, 6 months at minimum for the program. Well,
and you are aware that the state is proceeding on the Class A misdemeanor.
I just got reminded on that as well. If the state chooses to do so, we do have a little bit of flexibility. I would at least say, Your Honor, in that situation, if we can at least have 18 months to complete everything upon the program. I do apologize. Judge, you give me 1 second.
Sure.
Judge, if we can have 2 years, we could complete everything upon the program that we have laid out.
All right, and what specifically are you asking of Mr. Hernandez? What does he need to do?
Mr. Hernandez, as of today, Your Honor, Mr. Hernandez needs to give us a chance and an opportunity, like we ask every other veteran who is searching for help within our program, to meet us halfway to show him a different way. Mr. Hernandez does have military experience and military history, and we are both now in the understanding, I hope, that there are things that Mr. Hernandez can work on to change his future, to where during the assessment and during our initial evaluation, Mr. Hernandez, rightfully so, was not very aware of the trust and open and honesty that needed to happen so we could sell this case as a military nexus to the district attorney's office.
Let me ask you this.
Mhm.
When do you want him to show up for a meeting with you? Because I want specific dates for him.
Yes, ma'am. I would say, Your Honor, looking at the calendar here, I would need Mr. Hernandez on the 21st, next Wednesday, with me, Miss Alvarado, and one of my VA representatives who would either be Mr. Jihadi or Miss Nice, whoever's available at that time.
Okay, and what time is that?
Let's go ahead and do for 10 o'clock.
All right, and is that going to be by Zoom or in person?
I would prefer in person if Mr. Hernandez is still okay to follow the protocols that we did today when we spoke earlier, so we can have no misunderstanding. I feel Mr. Hernandez is a little bit more comfortable speaking to people in person if all parties are okay with that.
All right, Mr. Hobbs, is there going to be a problem with your client showing up to speak with Veterans Treatment Court in person?
I don't believe so, Judge, but Emmett, if you want to weigh in on that, I welcome your insight.
Mr. Hernandez, is there going to be a problem?
In person? And just so you
I
know,
need to hear you. You didn't say.
Yeah, you have to say things. Brenda is writing down everything that everyone is saying today. So while we see you shaking your head, she can't write that into the record.
Not have an issue with showing up in person with the veterans.
Thank you, Aaron.
All right, so if there's nothing else, anything else that he needs to do, Mr. Herman or Miss Alvarado?
No, ma'am. We have all the paperwork that we require for everything from the first evaluation. A lot of it now, Your Honor, is we need to vocalize and verbalize everything from Mr. Hernandez. So as long as he's there in person with an open, positive attitude and willing with his openness, that's all I'm requiring.
All right, and I'm assuming that if he is accepted by Veterans Treatment Court, you all will take care of any mental health issues as well, correct?
1,000%, Your Honor.
All right, so this is what I'm going to do. I'm going to go ahead and place him on deferred adjudication. And then we are going to reset this case after your interview with him so I can make sure that he's followed up on the interview. And if he hasn't followed up on the interview, then Mr. Hernandez, different things will happen. So this is what the court is going to do. Court is going to sentence you to 2 years deferred adjudication. There's to be no harmful or injurious contact with Danielle Hernandez. There's an affirmative finding of family violence. You are to meet with Veterans Treatment Court personnel on April 21st, 2021 at 10 a.m. in person. Mr. Herman or Mr. Alvarado, what location?
Your Honor, if he can meet us on the 3rd floor, right outside of the 186th District Court, and send us a text or a call when he's here, we will come grab him and bring him to the conference room.
All right, you're going to meet April 21st at 10 a.m. in person, 300 De La Rosa, which you're at the courthouse, so I assume you know where that is, 3rd floor, outside of the 187 District Court. Do you understand?
Yes, Your Honor, I understand.
And do you have the contact information for Mr. Herman and Miss Alvarado?
I'll be sending him that shortly, Judge.
Right. You're to let them know when you arrive. Do not be late. Do you understand?
Yes, Your Honor.
And
Your
Judge,
Honor,
can I
my
explain something
apologies.
briefly?
It's actually the 186.
The 186th District Court. Okay.
I'll get him that information as well, John. Judge, I saw my client's face kind of contort when you said something, and I think he had maybe a misunderstanding of what you said. Do you mind if I explain no harmful or injurious contact?
No, you may go ahead.
So, Emmett, I saw your face react whenever that was said. It's just what you've been under right now. You're able to live with your wife, your daughter, your whole family. You just can't have any harmful, injurious, or assaultive contact with them. So it's no different than what we've been under the conditions of bond. I just saw it look like you were a little bit confused when they said that, and it's normally where in person I'd lean over and whisper to you, but obviously we can't do that now.
All right. And my other question is, Mr. Hernandez, are you able to Zoom or no?
Yes, Your Honor.
All right. There's going to be weekly Zoom reporting until he is evaluated and accepted into Veterans Treatment Court. Mr. Hernandez, do you have employment?
No, Your Honor.
Is he on SSI? What is happening with his employment, or is he receiving benefits?
He's receiving 100% benefits from the military, Your Honor. He does help out his, it's a family business. His wife and his mother-in-law are in the court, and we're going to testify today about the relationship and how he does help with the business, et cetera. So I think he does go and help out a business, but he's not a full-time employee by any stretch.
All right. So it's going to be proof of benefits or employment within 30 days. There'll be regular UAs, or Mr. Hernandez, you can receive the patch. It just depends on people's schedules. I'll allow them to receive the patch or either regular UAs. With the patch, it makes it a little bit easier because you don't necessarily have to go into probation to take a UA. But the downside of the patch is the patch costs a little bit more. So that's something you and your attorney can discuss. If you prefer the patch or regular UAs, I give everyone a choice on that.
Judge, do you know the price difference off the top of your head?
No, probation will be able to tell you. I think it may be an extra $20 or something.
Okay.
All right. Mr. Hernandez, is there anything else you need from the court in order to be successful? All right, and I'm going to order the BIPP course. Rebecca, is there anything else he needs?
No, ma'am, I was going to ask you about the BIPP course.
All right, thank you.
Judge, would you consider, based on his disability and service, waiving the community service in this case so that he can focus on appointments with VA, working with John and Carolyn, with Veterans Treatment Court, et cetera?
Okay, I didn't order community service hours, did I?
Okay. I didn't hear you, but I know it was on the below the line recommendations by the state.
No,
But-
I didn't order that. And what I'm going to do is with the community service hours, I'll say 100 hours community service restitution, but I'm going to hold that in abeyance. We'll see what happens with the evaluation. And then based upon the evaluation, that may change. And Mr. Hernandez, if you're accepted in Veterans Treatment Court will be in charge of your supervision. So your case will be transferred there. The only time it will come back to me is if, one, you're asking me to come to your graduation, which I would really like to do, or they're telling me that you didn't participate and they're asking for a motion to revoke to be filed. All right, Mr. Hernandez, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. And also because there's an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
I'm sorry, could you speak up a little bit, please?
Yes, Your Honor. I understand.
All right, with that, Mr. Hernandez, I'm going to send you and your attorney and all of the probation officers and all of the Veterans Treatment Court to a breakout room. Norma, before they go to a breakout room, can we have a date for him to come back after April 21st? Mr. Herman and Ms. Alvarado, after y'all see him on April 21st, what is the time frame on when you all will know that you're accepting him and have accepted him?
Your Honor, the good news is since we meet every Thursday and we're meeting on the 21st, and this is more of a, we already have done the initial staffing. I could have an answer for you the next day, Thursday after staffing.
All right, so this is what we'll do. Norma, can you set it the week of the 26th?
Yes, ma'am. I can set it for 28th.
All right, so what we'll do, we'll set it for April 28th for you to come back here. For Mr. Hobbs, Mr. Herman, Ms. Alvarado, and Mr. Hernandez, if you're already accepted into the Veterans Treatment Court, then you don't have to come back on April 28th. So if someone will zoom in, if he's been accepted, or beforehand, just send us all an email, let us know he's been accepted. We won't have that court date.
Yes, ma'am. You'll hear from us right away.
All right, thank you. So what I'm going to do, I'm going to send you all to breakout room number 3. And then after that, you're all excused.
Thank you, ma'am.
You're welcome. Thank you for coming in, everyone.
Judge, I have a question.
Yes.
that is, sir.
I just wanted to know, was there gonna be time today available for you to talk to my wife and my mother-in-law?
Emmett,
Would you like me to speak to them?
I'm sorry?
I mean, would you like me to speak to them?
Well, I was just stating because my wife showed up and my mother-in-law also wanted to be present, and there was a.
Are they in the courtroom?
Yes,
They
ma'am.
are, Judge.
All right, let me, if you'll have them come up, let me have them come up and speak to them briefly, okay?
Yes, Your Honor. Thank you.
Sure, just have them come up. Deputy Laura, if you can have them come up?
Yes,
You want
Judge.
this on the record, Judge?
No.
Okay.
Just make sure you speak out loud. They're able to hear you. Get closer.
Hello, what is your name?
Danielle Hernandez.
All right, and
Elisa Harden.
all right, I want to let you guys know I appreciate you all for coming down. He's going to need a lot of support, you know, for his support system. The key to all of this working is going to be communication, okay?
Absolutely.
So just make sure that you both communicate with probation. You all communicate with Mr. Herman and communicate with his attorney. Because if I don't know something, then I'm just going to go by what's been put before me, okay?
Absolutely. Thank you.
All right, so yes?
Because I read the report that you have, and there was some things that were written on there that was not, I never had said or was true. So I don't know how I would be able to let you know that.
Oh, no, thanks for letting me know. But your husband's attorney has let me know that part of that, they disagreed with that. And that's okay. Here's the thing. When someone comes before me and they've been placed on deferred adjudication, we're starting at where we are now, and we're working towards improving behavior and improving what's happening, right? So anything that happened on that day, that has happened since, we're dealing with where we are right now. And where we are right now, he's going to be on deferred adjudication. He needs to make sure he makes all his appointment with the Veterans Treatment Court. And remember, communication is key. So we're going to need communication from everyone so this can have a good outcome, okay?
And Judge, just so you know, one of the things that I talked to both of them about were how things have been since the night of this incident and how they've improved. And both of them agree that things have been fantastic. He's actually been much more introspective and willing to think about some of the problems that he faces as part of his PTSD and actually trying to confront those. So that's why the main reason we had them here today was just talk about those things and how well he's doing, how well the family's doing, and that he's doing everything he can to help support everybody, including the family business.
Okay. All right. Thank you all so much for coming and let us know, okay?
Thank you, Judge. Thank
All
you.
right. Make sure, because usually I know, Brenda, and people get upset when I say this, but it's true. Usually women, I don't care if the men are in the military. When I was a defense attorney and prosecutor, usually the women in the family were able to keep up with all the dates. So you all know that it's next. John Herman, you know I'm telling the truth, right? So,
Yes, ma'am.
all right, so everyone, the next thing that he needs to do is he needs to make sure he comes back so he can speak with John Herman on April 21st, okay?
April 21st. Got it.
All right, and if you come into the courthouse, you'll have to wear the mask.
Okay.
So it's April 21st. It's on the 3rd floor. It's in the building that you're in, but on the 3rd floor outside the 186th District Court. And Mr. Hobbs will give you the information who to call to let you know that he's shown up. And he needs to show up on time. It's at 10. So get here a little bit early because you never know what traffic's going to be in San Antonio.
Okay. Thank you. Thank you, Judge.
Thank you.
All right. Thank you all so much. I appreciate you guys coming down and supporting him.
Thank you.
All right. So courtroom, if you can go to breakout room number 3, please.
Yes, Judge.
And John Herman, I'm sending you to 3.
Yes, ma'am.
Rebecca, I'm going to send you to 3. Colin Hobbs, let me find you. Yes, and I'm sending you to 3.
Thank you, Your Honor.
All right, who are the parties on Mr. Ruiz?
Paul Goki representing Mr. Ruiz, and I have his mother as a witness, Your Honor.
All right, just one second. State, are you ready to do the motion?
Yes, Judge, it's Oscar Salinas for the state of Texas. And the state has already submitted State's Exhibit 1, which is the offense report from the Attorney General's office. And I sent that to both defense counsel and to the court yesterday.
All right, just give me one moment. Mr. Goki, have you had a chance to review State's Exhibit number 1?
I have.
Yes.
His mother's name is Iruegas, Y-R-U-E-G-A-S.
All right, just give me 1 second, please.
Yes, ma'am.
Okay.
Before he takes off to TVC.
All right, sure, no problem. Oh, sure. All right, thank you. All right. Court is calling 2021 CR 1673, 2021 CR 1674, 2021 CR 1675, 2021 CR 1676, and 2021 CR 1677. Can I have parties announced for the record, please, for the state?
Oscar Salinas for the state of Texas.
For the defense?
Paul Goki representing Mr. Ruiz.
All right, and Mr. Ruiz, could you unmute for me, please? All right, are you Mr. Ruiz?
Yes, ma'am.
All right, Charles Roman Ruiz, correct?
Correct.
All right, I'm gonna make sure you need to speak up so that the court reporter can hear you.
Okay.
So are you Mr. Ruiz?
Yes, I am.
All right, we're proceeding by video because of the pandemic. Any objections from the state?
No objections, Judge.
Any objections from the defense?
No objection.
Mr. Ruiz, do you have any objection to this hearing taking place by video?
No, ma'am.
All right, we're here, defense, you file a motion in each one of these cause numbers for a bond reduction, is that correct?
Yes.
Defense, Mr. Goki.
Yes, ma'am.
And each of these cause numbers, you filed a motion for a bond reduction, is that correct?
It is, but the way I understand it is he has one $500,000 bond that we seek to get reduced to one $100,000 bond. I don't read the clerk's records as him having a bond in each case. But I did file a bond reduction in each case, just to be thorough.
Yes, and so that's what the court is going on. The court is going on what you found. So, Mr. Goki, it's your motion, you may proceed.
I would, yes, ma'am. It is a brief opening statement. Mr. Ruiz has never even been arrested before. The exhibit that Mr. Salinas referenced, I do not object to its admission for the purpose of this proceeding. I do believe it's a product of an illegal search and seizure, but I don't. That's
All
not a
right, well,
problem
just
for
one
bond
moment then. Let's stop right there.
Yeah.
So first, the state hasn't offered it into evidence yet. If you all have no objection to going out of order. And if the state wants to offer it into evidence, and if there is no objection, the court will accept that into evidence for the purposes of this hearing.
Correct. Yes, ma'am. I understand that. I was just seeking clarification of all of this. And I have one witness, and it is his mother, Miss Iruegas, and I would like to call her at this time.
All right.
Just-
Yes, state.
Just for the record, the state offers what's been marked as State's Exhibit 1 into evidence and for the purposes of this hearing.
Any objections for the purposes of this
No
hearing,
objection.
Mr. Goki?
No objection for a bond reduction hearing, Your Honor. You need
All right.
factual basis.
Okay, State's Exhibit number 1 is admitted. And Mr. Goki, I'm going to ask you to speak up because the court reporter is having a hard time hearing, and I'm having a hard time hearing you as well.
I'm gonna do my best. I'm in my car in the parking lot of the. I have a dental appointment in 15 minutes, and so I got sutures in my mouth. That's probably the problem. Are you able to hear me better now?
Yes, I am. So who is the witness that you're calling?
His mother, Miss Iruegas. It's Yuegas. She's been provided the Zoom link, and I spoke to her a while ago. She should be.
And what is
on
her
your
first
feed.
name?
Charles, what's your mom's first name?
Helen.
All right. Are you Miss Uriagas?
My first name is Maria Elena Iruegas.
All right. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, I do.
All right. You can lower your hand. Could you state and spell your last name for the record, please?
Iruegas, Yuegas.
All right. Defense, your witness.
Yes, ma'am. Thank you for appearing. Would you tell the court, how are you related to Charles Ramon Ruiz?
He is my son.
And to your knowledge, has he ever been arrested before?
Never.
Have you been, do you have personal knowledge of his family, of his finances? And have you been trying to help him make bills according to his finances? So you have detailed knowledge of his finances, correct?
That's correct. Since he got arrested, I've been paying all his bills that he has.
And is he able to make, first of all, did you make your best efforts to make a $500,000 bond?
Yes, I have, and to no avail.
What companies did you call?
I called McRae, I called AAA Garcia, AA Best Bail, Easy Out.
And basically, what is the financial requirement from these bonding companies?
They want 10% upfront and about 6 co-signers, and I'm not able to come up with that.
And is your son able to come up with that?
No, he's not.
Okay. Now, after trying to make a $500,000 bond, did you do your best to raise money to be able to inform the court an amount of money, an amount of a bond that you would be able to make as his family?
Up to now, the family is able to make a $100,000 bond. And
meaning you can pay the $10,000 fee.
meaning I can come up with the 10% that the bail bondsman requires, plus the co-signers that they require.
Thank you, ma'am. I pass the witness, Your Honor.
State?
No questions, Judge.
All right. Off the record for a moment. Mr. Francis, you need to go to breakout room number 1. And could one of the clerks go to breakout room number 1 to swear him in, please?
Yes, Judge.
All right. Defense, any other witnesses?
No, ma'am. I rest and I'd like to make a brief argument. Are you hearing me all right now?
Yes, I can hear you. Mr. Salinas, any witnesses from the state?
No, Judge. The state will just reserve its time for rebuttal.
All All right, defense.
Yes, ma'am. This type of offense arouses emotions in people. Possession of child pornography. First of all, it's a single arrest. The 5 counts are based upon 5 photographs. There were more, but they elected to file 5 counts based on 5 images. If you read the exhibit before you, Your Honor, you will find that there never was a more cooperative suspect arrestee. Certainly not in my experience. He cooperated completely with law enforcement. Now, the issue of child pornography arouses emotional feelings in individuals, and they think of pedophilia and child sex abuse. However, the Scandinavian countries began experiments in the 1960s with legalizing child pornography and found that it led to a decrease in actual child sex abuse, child violence, pedophilia behaviors. Access to child pornography reduced the likelihood of that. That was in the 1960s. That experiment has been replicated several times since then. And every time that a jurisdiction has legalized child pornography, it has resulted in a reduction of actual offenses against children. Now, it's not to say that child pornography is a victimless crime, particularly if the images are not simulated. And so a person who has child pornography is enabling that market. And for that reason, I cannot dismiss this as a victimless crime. However, the idea of incarcerating him under a $500,000 bond for the protection of society is contrary to the scientific evidence, which indicates that his possession of these items, if he did, reduces the likelihood of any kind of actual offense. This is well established scientifically. And for that reason, I believe that he deserves to have a $100,000 bond, which is what the family can make so that he can get out of jail, never having been arrested before. And though there has been, this case originates with the Attorney General's office. So there has been a full investigation of Mr. Ruiz, and there's never been a hint of the actual offense, any actual impropriety with children anywhere. He possessed images which are contraband under the law, but he does not need to be incarcerated under an impossibly high bond. Thank you.
State.
Well, I think the first thing to point out, Judge, is that looking at the report on page 6, I'd like to note for the court that the defendant is accused of uploading up to 578 images of child pornography to cloud storages off the Verizon wireless server. And so what does that tell us? That tells us that there are 578 different offenses that occurred. Each one of those offenses in and of itself are punishable up to 2 to 10 years in the penitentiary. That can, as this court is very well aware, can be stacked upon each other. And there's a reason for that, because this type of material leads to dangerous actions. Again, he is downloading, and I personally don't like to use the term child pornography because in fact it is child abuse material, because each one of those images shows a child being sexually abused. And I would like to note that one of the images that was mentioned in the report on 1.4, which is shown on page 6, shows a child being tortured in the effect of having her limbs tied and being sexually assaulted and being on display in a lewd manner. This is a person who is sexually attracted to children. So the question before the court is, what is an appropriate bond for a person who has committed 578 separate offenses of possession of child pornography, each of which shows his desire and his sexual attraction towards children. Now, I know that I just got emailed this Scandinavian study, and I have not read it and I have not reviewed it. But the simple fact is we can use our common sense and understand that this defendant is downloading and uploading images of child sexual abuse because he fantasizes over that. And that is the reason why his bonds are appropriate, in order to keep the community safe and keep a person who is sexually attracted to children under close monitoring and supervision of the court, and ensure that a person who is facing quite a substantial number of years, not only in his 2 to 10 on each count, but the fact that he can be stacked is a reason why his bond is currently set at the appropriate amount.
All right,
Madam
defense, it's your motion, so I'll allow you final argument.
Yeah, yes, ma'am. So the idea, that's why I began with protection of the community, because the scientific evidence is completely contrary to that. Meaning that he is the idea of a sexual attraction to children is fairly understood in psychiatry and psychology. It typically
Your Honor,
develops.
at this point, I'm
Okay, here's the thing, the court,
studies.
all right, the court will hear argument.
It's fairly understood, and typically it is thought that a person can develop what we consider an unnatural attraction when they themselves have been victimized as children. This is a man who has been fully investigated by the Attorney General's office task force with regard to these type of offenses. And there is not a hint of any actual impropriety. Now, with regard to the potential sentence and the like, that's why I pointed out to the court that a review of the exhibit will show you that there never has been, in my 30 years of experience, a more cooperative defendant with law enforcement when they were approached than this man. He cooperated completely. I say that because he will appear in court as directed. He is facing the reality of this illness in him and will do something about it. But he will cooperate with this court the way he cooperated with law enforcement. And this is hard evidence. And the science that I've recited to you is hard evidence and is contrary to the state's argument that he is at risk of actually offending against children.
Okay, all right, thank you for your argument. The court has reviewed state's exhibits number 1, and the court has listened to both arguments. In each of the cause numbers, the court will deny the motion for a bond reduction, and in each of the cause numbers, if the defendant makes bond, the court will order full GPS. With that, we will close the record. And your client's next court date, and it's for discovery, is May 17th. So I'll see everyone back here on May 17th. Mr. Ruiz, we'll have you come back on May 17th, okay? All right, thank you.
Thank you, Judge. May I be excused?
Yes,
Thank you kindly.
you're welcome. Norma, can you let them know that Mr. Ruiz can go back? He's 14E.
Yes, ma'am.
And who is the who is the state on Rodney Ferguson for Christine McDonald?
What is it? What is this, Judge?
It is Christine McDonald is here for a motion for a bond reduction on Rodney Ferguson.
Did we talk about this, Christine? No, we have not. If we could confer, Judge.
All right, I'll send you, Christine, I'll send you to breakout room number 1.
Thank you.
You're welcome. And Alexandra, if you can go to 1. All right, and Roman Ruiz, were you here for something?
I was just supporting my son, Charles.
All right, thank you so much for coming. Helen, I'm sorry, I can't pronounce your last name very well. I promise you I'm going to work on that. But Helen and Mr. Ruiz, I appreciate your coming in today, okay?
Thank you.
Okay, ma'am.
All right, thank you.
Thank you. Bye-bye.
All right, Kelly Piddle, are you ready on your case?
We're ready, Judge. Paperwork's in.
All right, who is the prosecutor on this?
Marcus. Let me call you back. Yeah.
And Judge, we have an impact statement on this one also.
Okay. All right, the court is going to call 2021 CR 2317, State of Texas versus Alex Rayborn Francis, and cause number 2020 CR 1383. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Kelly Piddle.
And are you Mr. Alex Francis?
Yes, ma'am.
All right, in each of these cases, we're proceeding by video because of the pandemic. Any objections from the state?
No objection.
Any objections from the defense?
No.
Mr. Rayborn, in each of these cause numbers, I'm showing you what's entitled Defendants Consent to Appear by Video. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them?
Yes, ma'am.
Court will find that in each of the cause numbers that the defendant has knowingly and voluntarily consented to appear by video. We're going to proceed first with 2021 CR 2317. Defense, I'm showing you what's entitled Acknowledgement of Discovery. Have you received all the discovery in this case, and did you review it with your client?
Yes.
Mr. Piddle?
Yes, Judge.
Court will find that the state is in compliance with discovery. Mr. Francis, I'm showing you a document entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge, we are.
Mr. Francis, I'm going to show you a document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it, and did you electronically sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with is aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison with the possible fine up to $10,000. Did you understand?
Yes, ma'am.
All right, off the record for a moment, Brenna. To the courtroom. My understanding that Mr. Smith is here. Could you go to breakout room number 2?
Yes, Judge.
And if there is a prosecutor available to confer with Mr. Smith or Mr. Peavy, the cause number is 2019-11517.
Judge, that was one of my cases.
Okay, well, we'll wait then. All right, we're back on the record. Mr. Francis, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Francis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea in this cause number?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter a plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. There's an affirmative finding of deadly weapon. There are no applications for deferred adjudication. This will run concurrent with 2020 CR 1383. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal. Did you review that paragraph with your attorney? Did you understand it, and did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then Mr. Francis, to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 and its attachments.
Any objections?
No objection.
Mr. Francis, I'm going to show you a document entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments and will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, just ask that you follow the plea bargain.
Court will sentence you to 5 years in the prison, give you credit for any time served. This will run concurrent with 2020 CR 1383. And there's an affirmative finding of a deadly weapon. Next, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
Next, we're going to move on to 2020 CR 1383, showing you a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alex Rayburn Francis, who was placed on deferred adjudication in 2020 CR 1383 for the offense of criminal mischief, 2,500 to 30,000 on May 20th, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
State.
Condition number 1, on or about the 6th day of December 2020 in Bexar County, Texas, the defendant, Alex Rayburn Francis, committed the offense of assault in violation of condition number 1.
How do you plead to that, true or not true?
True.
We'll waive the rest.
Any objections to the state's waivers?
No, Your Honor. He's on probation for possession with intent to deliver PG 2A 1 to 4 grams.
Yes.
Okay, just want to make sure that.
This is incorrect. Just 1 second. All right, everyone, we're going to go off the record for a moment. Mr. Piddle, Mr. Sanders, do you all want to make an oral change, or do you want Ms. Reyes to print out another document?
I can make an oral motion if Kelly has no objection.
No objection, Judge.
All right, just 1 moment. All right, we'll go back on the record. All right, according to the plea paperwork and according to the judgment, when the defendant first entered his plea, what he entered a plea to was possession with intent to deliver a controlled substance, penalty group 2A, 1 grams to 4 grams. The deferred adjudication document that the court has states that the defendant is charged with criminal mischief. Are there any motions with regards to that document state?
Yes, Judge. The state would request that the motion and the document be amended to correct the charge to possession with intent to deliver penalty group to 2A, 1 to 4 grams.
No objection, Judge.
All right, and both parties are aware that this is a substantive change to the motion, but both parties wish to continue with the oral amendment. Is that correct? Defense?
Yes, Judge.
State?
Yes, Judge.
Mr. Francis, are you asking us to continue with the oral amendment to the deferred adjudication?
Yes, ma'am.
All right, then, Mr. Francis, I'm going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney and did you understand it?
Yes, ma'am.
All right. According to the motion, are you the same Alex Rayburn Francis who was placed on deferred adjudication in 2020 CR 1383 for the offense of possession with intent to deliver a controlled substance, penalty group 2A, 1 gram to 4 grams on May 20th, 2020 for a period of 2 years? Is that you?
Yes, ma'am.
All right. State?
Condition number 1, on or about the 6th day of December 2020 in Bexar County, Texas, the defendant Alex Rayburn Francis committed the offense of assault in violation of condition number 1.
How do you plead to that? True or not true?
True.
We'll waive the rest.
Any objections to the state's waivers?
No.
Mr. Francis, did you understand by pleading true to violation of condition number 1, the court could find it true, find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
All right, the court will find violation of condition number 1 true. Is there an agreement?
There is, Judge. We're asking that you grant our motion, adjudicate and revoke and sentence Mr. Francis to 5 years TDCJ.
Is that the agreement?
It is, Judge. It's asked that it run concurrent with his other case.
Mr. Francis, are you asking the court to follow that agreement?
Yes, ma'am. Please, if you can.
All right, are you waiving your right to appeal?
Yes, ma'am.
All right, the court will follow your agreement. The court will grant the motion, find you guilty, not grant you community supervision, sentence you to 5 years in the prison. This will run concurrent with 2021 CR 2317 and give you credit for any time served.
Yes, ma'am.
Next, in this case, I'm going to show you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, with that, we'll close the record. Mr. Francis, it's my understanding that there is victim impact. So what that means is the complainant in this case has a few words for you. This is what I require in this courtroom. In this courtroom, I require that everyone treat everyone with respect. So internalize what's being said. She won't be disrespectful, or whomever it is won't be disrespectful to you. So don't be disrespectful to them. Do you understand?
Yes, ma'am.
All right, and Mr. Francis, you're going to need to change your life. Whatever is going on, you need to change it. Otherwise, you're going to find yourself living in prison. You understand?
Yes, ma'am.
All right, who do you have to speak, State?
Tiffany Dean.
All right, and we're off the record, Brenda. Ms. Dean, you may begin.
Yes, ma'am. Thank you, Judge. I just wanted to say I never meant for any of this to happen. And by me not knowing the defendant at all, just by acquaintance, it really bothers me. I would pray at night and I keep praying. And I want to continue to praying for Mr. Francis as well as myself. None of this should have never happened, and I'm going to continue to pray. I wish it never would have happened. I'm very heartbroken over the situation because kids were involved, and none of us need to be taken away from a child at this point in time. So all I would like to say is, please think about everything and family and love one another, because the world is actually closing in on us as we speak. Thank you.
All right, thank you, Ms. Dean. All right, Norma, can you let them know that Mr. Francis can go back? And state, did you need to speak with Ms. Dean anymore?
No, Judge, we'll contact her.
All right, thank you.
Thank you.
And
His chair number?
he doesn't have a number attached.
Okay, I will let them know.
Thank you. Mr. Francis, just stay there. Mr. Francis, stay there until someone comes to remove you.
Yes, ma'am.
All right, and then Mr. Courtroom, if you could go to number 2, and Mr. Sanders, if you can go to number 2.
Yes, Judge.
Bobby Gebbia, you're here?
I am here, Judge.
Yes. So what is happening with Mr. Bell?
We had Mr. Bell set for sentencing this morning. He pled a few weeks ago. Tom Nisbet is the prosecuting attorney. Tom and I spoke this morning. We went over a couple of changes that needed to be made based on the enhancement allegations. My wonderful associate Laura noticed that there were some errors in the enhancement allegations, brought that up to Tom. They conferred about it. Tom can clue you in on the specifics. My understanding is now is the state intends to waive all of the enhancement paragraphs. Is that correct, Tom?
Yes.
With that being said, I met with my client yesterday. We went over that. He is present in the courtroom today with the enhancement paragraphs as they are, and with some other things that he asked me to go over. He is asking for a reset today. I talked to Tom about that. Tom and the state oppose a reset, but considering and in light of the changes that need to be made to the plea, which we can do on the record, I don't think any documentation needs to be redone, although if we wanted to be, super ultra mega complete, as my wife would say, we could go ahead and do that. But I think we could probably just waive the enhancement paragraphs on the record and it wouldn't change much of the plea. But still, we are asking for time to continue to go over a few things. Additionally, Tommy Bell is accompanied in the courtroom by his father. He lets us know that his father is terminally ill and he has a scheduled biopsy tomorrow. And Tommy would like to be present for the biopsy with his dad tomorrow also. And that's where we're at there, Judge.
All right. I'd like to see the state and the defense in breakout room number 1, please. And Norma, could you join us in breakout room number 1, please?
Yes, ma'am.
All right, Mr. Smith. You're here on Mr. Peavy.
Yes, Your Honor. Marcus and I spoke briefly. I had filed 4 motions. The court has granted the motion to withdraw, which leaves 3 open motions. I feel uncomfortable going forward on those because I'd asked.
No, I mean, because the motion to withdraw has been granted. So if there is an attorney who's appointed for the appeal, Mr. Peavy, can you unmute for me, please?
Yes, Your Honor.
Yes, Mr. Peavy, are you going to be requesting an appeal on these cases, on this case?
Yes, Your Honor.
All right. And basically, do you know what an appeal is, Mr. Peavy?
No, Your Honor.
All right. So this is what we're going to do. Mr. Peavy, an appeal is where you're saying, either you're saying something was done wrong and it shouldn't have been done that way. I'm trying to speak in layman's term. Or either you're saying, I don't like the sentence I received. And that could be what an appeal means to you. But in layman's term, an appeal is you're requesting a do-over. And there has to be an attorney that will be appointed to represent you. And then that attorney will make whatever arguments they want to make to a different court or maybe to me, saying this is why you should get a do-over. Do you understand?
Yes, ma'am.
All right. So are you going to be requesting an appeal? Because your attorney, Mr. Smith, has filed a motion to withdraw saying that you want an appeal.
And then he said he didn't like the other 3 though, right?
No. What he's saying is he's filed 3 other motions. One of the motions he filed is a motion to withdraw. So what that means is if there's an appeal, another attorney will handle that appeal or be the attorney on that specific part of the case. Mr. Smith will not be. So I'm trying to find out from you, if you want an appeal, we will have an attorney appointed to represent you for that. Do you understand?
Yes, Your Honor.
All right. Norma, just on the safe side, can you get an attorney appointed to Mr. Peavy for purposes of appeal? Can you see who comes up on the wheel?
Yes, ma'am.
And then Mr. Smith, I signed your motion to withdraw, so you're excused. We're going to make sure if you want to remain, you can. I'm going to make sure that Mr. Peavy knows who his appellate attorney will be.
Very well, Your Honor. Thank you.
And if there's any information you can give that attorney, then that will be greatly appreciated by the court.
Thank you, Your Honor. And Daryl, the satchel that you left here, the notebook, I'm going to get that to Olivia.
Okay, thank you.
You're welcome.
You're not going to be my attorney anymore.
Well, I don't think it's a good idea for me to grade the papers. In other words, if there is an error that is made, it should be looked at by someone else. But we'll talk some more. I wanted to get you before the court before the time is up, so that the court could appoint an attorney, and the court will appoint an attorney.
I'll miss you, man.
Judge, I just sent you a chat.
Okay, just one moment. All right, Mr. Peavy, the chat that was sent to me is that the court coordinator is looking to see who comes up next on the wheel, because we have to do appointments by what's called the wheel. And so it's someone who does appeals, okay?
Yes, ma'am.
Everyone, just give me one moment, please. And Mr. Tochi, I'll be right back. All right, Mr. Peavy, I've been told that the will has appointed Angela Moore as your attorney for any appellate issues. So
Yes,
what
ma'am.
we're going to do is we're going to see if she can zoom in. Mr. Smith, if you'll just give us a few more moments, let's see if she can zoom in so that Mr. Peavy can meet her and you can introduce her to Mr. Peavy as well.
Very well, Your Honor. Thank you.
Thank you. I appreciate your patience. James Toshi.
Hey, Judge.
Hi, you're here for an off docket matter?
Yes, ma'am. I'll
Which case is it?
Well, that's kind of part of the deal. It's a bit of a discussion. He's already been sentenced, Judge. His name was Roland Luna. He was sentenced to prison time back in February. My question is this: is there any way that I could possibly get you to sign? It has to do with the no contact order. You had indicated as part of the judgment that you have no contact with the complainant. That she's expecting his child. They have every intention of trying to get back into contact when he is paroled. But as it stands right now, she cannot call him in the prison or have any kind of communication with him based on the order by the court, which I understand. I don't know if the court would even consider perhaps sign, and I can get an affidavit from her, Judge, indicating she would like to have contact with him. Apparently the warden of the facility indicates that if the judge does away with the no contact order, she can then make phone calls, et cetera, et cetera. So I told her I would make inquiries. One solution I had possibly was a nunc pro tunc, because I'm not sure what jurisdiction the court has at this point.
No. What is the cause number?
Oh, God.
Judge, I can tell you.
Okay.
It's 2021 CR 1612W.
All right, let's do this. Let me see if the clerks can find where that file is, because I don't think that file is in the court anymore.
Probably
And
not.
I need to read what's in the stipulations, because before we go through all of this extra thing, I want to see if it's something that I would consider doing.
Okay.
And then
Well,
if it's something I would consider doing, then yes.
I was just going to say, sorry to interrupt, Judge. I was just going to say, while Tochi is here, we're going to be doing a plea tomorrow on an intox man. And that's going to have victim impact on it. So since it's the court and Tochi and the state all here, can we agree to do that after lunch, just so I can give a more definitive time of when it will likely happen to my next of kin people right now? Are you okay with that, Jim?
Yes, I'll tell you what, let me see you both in a breakout room. Let me, James Toshi, if you could go to breakout room number 1.
Sure, Judge.
And Mr. Smith, if you'd like to have a seat, we're trying to, that way you don't have to continue to stand, and we can see if Angela Moore is able to come in.
Judge, it keeps going to voicemail.
Oh, I have a contact number for her.
Thank you.
Sure.
Marcus,
Yes, ma'am.
can you move people around?
Yeah.
Can you move Christy McDonald and her client into a breakout room?
Yes.
Thank you.
Marcus,
Yes. Oh, is she in the courtroom?
no, I need a breakout room, please, with Bobby Gebbia, please.
Okay. You're already in 2. I'll send Bobby to 2.
Thank you.
Okay, I'm here. Sounds good. Thank you.
Norma, who's Christine's client?
Rodney Ferguson, he's in.
Rodney Ferguson. Sorry, I was on mute, Christy.
Oh, no worries. Thank you for.
You're welcome.
And where's he at? I don't see him.
He's in custody.
Norma, is he supposed to be on screen? Because there's no one in the breakout rooms other than Bobby and Deputy Laura. Norma, can you check your chat?
Okay, Marcus, I hear you now. What's going on?
I don't see Rodney Ferguson on the screen or any breakout rooms.
Let me find out where he's at. Hold on.
All right, Mr. Peavy, I made contact with your appellate counsel, so they're going to be zooming in.
Yes, ma'am. Thank you, Your Honor.
You're welcome. Just give us a moment. And Rebecca, I'm going to fill out the paperwork that you sent me.
Okay, thank you.
Judge, may I just briefly go back into the 379th? We were doing mental health staffing.
Yes, and what is the status of your case that you're here for?
Your Honor, I spoke with the state and they did offer a reduction on one of the cases as far as the bond. So I'd like to speak to my client about that to see if we need to pursue a contested.
All right, and is your client Mr. Ferguson?
Oh, here he is. Yes, I guess they found him.
All right, I'll send you to a breakout room with Mr. Ferguson.
Thank you,
Mr.
Judge.
Ferguson, let me see here. I'm going to send you to breakout room number 2 to speak with your attorney.
Christine, I think your client went back into the breakout room. Is there any way you can go back in and get him?
Sure, let me check.
We're ready whenever on that case, Judge.
All right, thank you. Just give me a moment. All right, Mr. Peavy, we were having a little bit of slow moving email. So the attorney has just let me know that she's received it, so she'll be zooming in shortly. Christine, and here she is. To the courtroom.
Yes, Judge.
I'm going to send you all to a breakout room. And I'll send you to breakout room number 1. And Mr. Peavy, I'm going to send you to breakout room number 1. And Ms. Moore, I'll send you to breakout room number 1. All right. So Mr. Ferguson, what is happening with Mr. Ferguson?
Your Honor, I conferred with the state. They are willing to lower the 3rd degree charge, which is NM 606198 to $10,000, Your Honor. At this time.
Just 1 second, let me find it.
I'm sorry.
So 606198, what are they willing to reduce it to?
It's to 10,000, Your Honor. It's currently set at 20,000. Is that correct, Ms. Williamson?
Yes, that's correct.
All right, and what is happening with on 606197?
Your Honor, at this time, the state is not in agreement to lower the charge. I've discussed I've discussed with my client his options with a contested hearing, but after discussing it, Your Honor, we decided to go with the agreement and to readdress this if my client is not able to bond out.
Okay. So the court will sign the agreed order then on NITMAC number 606198. Are there any conditions associated with that?
Your Honor, we haven't spoken about that, but I think these 2 cases will be indicted in one charge. There'll be a multi-count indictment. But I do think that if he is able to bond out, maybe some sort of GPS would be appropriate. Christine and I spoke about the victim's feeling on this case, and I do think that would be appropriate, or some sort of curfew, at least so we can monitor him a little bit better.
And Judge, I looked it up on the D page, and it looks like there is a GPS partial arrest with the no contact order with Kim Clark, Your Honor.
You say Kim Clark?
Yes.
Yes. And we'd be fine maintaining that, Judge.
All right. So what I'll do is I'll sign it as an agreed order, setting the bond at $10,000, and all other conditions will remain.
Okay.
All right. Is there anything else?
No, Your Honor, just one last thing. I noticed on the D page that with the GPS monitor, there was a notation that fees would be waived, and I'm just respectfully requesting that to remain as my client is indigent, Judge.
Yes, could you do me a favor? Could you go, for some reason, your client went to breakout room number 2. Could you go to breakout room number 2 and have him come back to the main room?
Sure. I'm sorry about that. One second.
Oh, no problem.
They're back, Judge.
All right, Mr. Ferguson. If you could unmute for me, please, just hit the space bar twice. That's what I'm being told that works by our tech person, Brenna DeMoss. If you'll hit the space bar twice. Well, hit it once.
You gotta hold it down.
Hold it down.
There
Okay, let it go. Don't touch anything else. Mr. Ferguson, hold the space bar down. Let it go. Oh, now we know you got to hold it down. Just continue to hold it down. All right, Mr. Ferguson, on cause number, night bag number 606198, where you're charged with assault family second offense. The state and the defense have agreed to a $10,000 bond. All of the conditions will remain. The court is requesting that GPS fees be waived, or either you be placed on indigent status for GPS fees. And then on cause number night mag 606197, that motion is being withdrawn by your defense attorney. And if you all decide to have the court to hear that, of course, the court is always available to hear that.
Okay.
Your
All
Honor,
right.
that's
Yes.
all I have. May I be excused?
Yes. And Norma, can you let them know that Mr. Ferguson can go back? He's L12.
Thank you so much, Judge.
Yes, ma'am.
All right, thank you. And everyone, with that, I am going to stop the live stream. We will handle other matters off docket. Ms. Ferguson,
Yes.
where is Stephen Gill? I'm sorry, I mean Court Coordinator Ferguson. Maybe you two are related. I don't know. Ms. Ferguson, have you seen Stephen Gilmore on Rebecca Rojas?
No, ma'am.
All right, thank you. All right, everyone, we're going to stop.